Ladies and gentlemen, welcome. This is William Keat of lawandalchemy.org and commonlawconstitution.org. Welcome. So this is an important video. Why a legitimate constitution is required under natural law. So I did a recent video that sort of did it the other way around. It's basically, I was saying that in order for you to understand your constitution, you need to understand natural law. This one is making the point that it works the other way around as well. That in order for natural law to manifest in your community, you are going to need some kind of a legitimate constitution in place. It has to be there, and some are not going to like this. Okay, in particular, I would say there are a number of commentators out there at the moment, and I would say that there are some anarchist and voluntarist leaning communities that will not like what I'm saying. Now, I should say that I've come through that route of anarchy and individualism and voluntarism. I came through that route and I have sympathy. Yeah, I like anarchists, I like voluntarists. But this is important because there is a piece that's missing in that world of anarchy and voluntarism that I'm sorry, I'm going to say it, and it's the safe containment bit. And what I'm finding is that there are people who, slightly egotistically, I think, have discovered this sort of exciting new tool, natural law, and they think that they can sort of wield this out of control. And because they've found it, it's almost like the subtext is almost like they can dismiss anyone who's now going to talk about governments or constitutions. And I'm saying no, because that lacks nuance. It lacks a piece that's missing, I think, here. And it sort of demonstrates a kind of violent swinging on the journey of discovery. So, that might trigger a few people, but, go with this, stick with this. Now, what I'm saying is that you can't divorce the framework of how natural law principles are embodied within your community from natural law itself. Okay, so what I'm saying in effect is that your framework of governance, which is your constitution, is a microcosm of natural law. And you can't divorce that from natural law itself. Now, why is that? Because the framework itself is both a manifestation or even a reflection of natural law. Yeah, and if you could put it another way, actually, you could say that this is it's a model that is aspirational and has ideals for how to embody and manifest natural justice. Yeah, so you could say that as the community develops, it contains ideals and aspirations for how best to put natural justice into effect. I'm just following some notes here. So I suppose another way of putting it is that you could say that it's how the community itself develops its operating conditions for how to put natural law principles or natural justice into the way that that community governs itself. That's what you're doing. It's manifesting a series of operating conditions. Now, is there only one way of doing that? Is the English law tradition the only way of manifesting the principles of natural law in your community? No, not necessarily. But there aren't many. And I would possibly even dare to argue that it's the only one, certainly in the West. So yes, there are other ways in which those principles could be reflected, if you like, in one's community or governance. It's not the only way. Now, what I'm actually saying, though, is that at the foundational level, there will be certain principles that must be adopted. Yeah, there are certain natural law prerequisites, if you like, features, not features, actually, principles that must be included within your practical constitutional framework, which would make it legitimate if it was in alignment with natural law. Okay, so what might those principles be? And I've actually listed 10 here, so I'm going to run through them very quickly. So one, the public servants will emerge, which will be the seeds of what we have later in the English system called government. Okay, so in any community, there will be people stepping up. If you like, you can think of it. This is my second one, actually. The beginnings of government is merely a collection of people of the community stepping up in their responsibility to do the jobs that need to be done. Yeah, that might be keeping people safe, security in some way, a wise elder, conveners, etc. Yeah, there are going to be people in your community that are going to step up, and in the beginning, it's going to be people who are perhaps volunteering to do that in your community in a small micro way. Yeah, but that's really what government is. That's what it started as. So three, that the people at large, that's the population and not its public servants, must have ownership of justice and the laws of their community. They must be the final arbiter of law. The people should not and do not outsource or hand over the responsibility of judging justice by creating an authority. That's a principle. Number 4, justice for potential crime or between parties, disagreement between parties, must be judged by the community in some way in order to maintain equity. So remember that equity is a principle in natural law, that we're all equal under the law. Yeah, and we're all held to the same set of standards. Now, in order to maintain equity successfully, you're gonna have to have some kind of a justice framework in which parties must be judged by the community themselves in some way in order to maintain that equity, not be outsourced to the public servants. 5, you can't be the sole judge of your own actions when another party is involved, right? So, in a way, if there's a potential crime is hurting someone else. So therefore, that presupposes that someone else is involved, necessarily so, right? And therefore, you can't be the sole judge of your own actions. Yeah, you can't take the law into your own hands. Yeah, it's going to involve other people's judgment as well. And that's a difficult one for anarchists to understand, but it must be. Otherwise, you don't have, you're breaking natural law, essentially, there. 6, justice is centered around healing and self-improvement and must be delivered through conscience and discretion. I would say that's a principle of whatever you develop in the way of your governance in your community. 7, justice must be judged individually and not delivered through shortcuts or a predetermined formulaic distribution of punishment. So what is that? Legislation from your public servants. Can't do that. Okay, that's not how justice is achieved. Always delivered individually and judged through conscience and discretion. Eight, the public servants must never gain an autonomy of their own that would affect this very framework of governance that we're talking about now, lest that they give themselves greater powers and break that equity. Right? That's really key, right? The public servants must never gain an autonomy of their own that would affect this very framework of governance, lest they give themselves greater powers and break equity. You can't have that. So let's just translate that into a problem that has developed and a distortion in our own English law system. It's the claim that government itself, through its own lawmaking mechanism, the legislature, can rewrite the constitution such that they can get out of their limitations. That's a problem. That's a principle that must be built into the constitutional framework of your community. Must be there. 9, a wise elder takes responsibility for keeping this framework in place and understands that he is merely one of the community performing this role for the rest. Yeah, a wise elder, a servant to the people. Yeah, I know that sounds a little bit different from in the English law tradition from the way that some of our monarchs have behaved. I get that. I concede that, obviously. 10. Last one. This ownership of this framework remains with the people and not that of any officials or public servant roles that may emerge from it. In other words, this very framework, this constitutional framework, the constitution that you create from it, remains the property of the people. Yeah, it doesn't become owned by whatever emerges as a government or an administration, because that's where things go really badly wrong. Now, is that an exhaustive set of principles? Not necessarily. You might be able to think of some others that I've missed. Okay, but there's a 10 broad brush principles that I would say any community on this planet would need to adhere to for that constitutional framework to be legitimate and therefore reflect natural law principles. Okay, I'm sure there are others that you could think of. Now, all of those principles are in alignment with natural law. And denying those principles, I would say, or precluding them in some way, is running counter to natural law, is going in opposition to it. And doing that will begin to manifest disharmony and chaos within the community. Funnily enough, that's now what is happening. Okay, it doesn't mean to say that the framework itself is wrong. It means that we've forgotten it, and I'll come on to that in a moment. Yeah. Therefore, the adopted customary principles of how the community embodies these features of natural justice is the practical reflection of natural law and natural justice. It's an embodiment or a reflection of natural law. Yeah. So a constitution will manifest in some form. If you are in alignment with natural law, it will naturally come about anyway. A constitution that is a legitimate one, not an illegitimate one, can always manifest in some form containing details such as what the wise elder customarily promises to uphold when taking up that role, for example, or the broad nature of how justice is dealt with. Yeah, there are going to be some principles, some slightly more detailed principles that are going to be laid down in customs and traditions of how you in your community, in your part of the world, manifests natural law. And it's interesting that I've discovered, and those around me who've been doing that discovery on trial by jury, for example, in the English tradition, is that in Europe, when people were largely left to their own devices, in many locations geographically, they began to form justice bodies, if you like, of a body of justice, an institution, if you like, not an institution, that's a bit formalized, but a tradition, if you like, of a body of people, usually of 12 people, by the way, that would deliver justice in some form. Yeah, all over Europe, Scandinavia, you see clues of that everywhere. You know, way back in the 1100s, even earlier than that, a couple of hundred years before that, and going back into to Saxon times too. So this set of principles is necessary as the safe container for the community. Okay, so I'm going to describe that as the safe container. Why? Because without it, you will go into a condition of raw anarchy. And what I'm saying, even though I've come through that anarchist route, if you like, without it, you will fall out of alignment with natural law. Why? Because a condition of raw anarchy will emerge And that is not in alignment with natural law. I'm sorry, guys, it isn't. Because you can't take the law into your own hands. I'm not talking about the mainstream definition of anarchy here, which is like hurling stuff around the street and setting fire to things. And that's not what I'm talking about. I know that, obviously, right? I'm talking about the more sophisticated version of anarchy, no external rulers, etc., etc. I get that, right? But even that is not really an adherence to natural law either. And I think people are not going to like me saying that. Yeah, you won't have that safe container in a raw state of anarchy. You are open to manipulation by others. You can't be held as the only judge of your actions. You can't be the only judge of your actions. Yeah, it requires interactions with others and the judgment of others. Justice requires that. As soon as we're talking about a community, then your potential criminal actions affect others, and therefore the judgment of justice naturally must involve other people. You can't be a judge in your own cause. So the question then immediately, logically comes up is, if under natural law you can't take the law into your own hands, then it follows logically that in your community, in order to reflect natural law, you are going to have to define customs or traditions of how you do that, of how you do justice, how you manifest it. Yeah. So the how becomes the features and customs of your community's governance. And that is your constitutional framework that must be in place. It must reflect natural law. Yeah, and so in the English law tradition, trial by jury specifically for justice was discussed by Alexis de Tocqueville brilliantly in his book. Now, listen to this. He says the jury, quote, is both the most effective way of establishing the people's rule and the most efficient way of teaching them to rule, end quote. And he went on actually and described the jury as, quote, a political institution embodying the sovereignty of the people and the very best way of preparing a people to be free, end quote. I couldn't put it better myself. It's just brilliantly put. So what he's doing is he's talking about the trial by jury system or tradition of the West. Yeah, and in order to have that tradition in place, you're going to have it as a framework. You're going to have it as a constitution, as a set of intentions. Yeah, and some people, of course, at this point will say, well, the jury didn't work. I've been on a jury, it didn't work. I've seen the jury, I've seen bullying in it, I've had stupid people. Yeah, I know all of that happens. Yeah. But maybe that's a reflection, perhaps, of them not standing up in that situation and speaking out when they should have done. Maybe there's a projection there on and maybe blaming the system itself or the mechanism itself for their own failings, perhaps. It's just a suggestion. I'm not saying that that is the case. Yeah. Um, don't forget these key things, right? Is that we need to keep alive in the minds of the public why and how it is that the jury is supposed to work. Yeah, how the judge should not be directing the jury. And how jury independence, for example, that concept of jury independence, the right of the jury to judge the legislation as well, that's being hidden from people, which is kind of a lie. It's a lie to the general public. Yes, that's a distortion, but it's not your constitution. Yeah, the real constitution actually says you should know that. So what I'm saying is that a framework of governance arises within a community that has an understanding of natural law. That framework of governance will naturally arise anyway. It's a reflection of the understanding of natural law. Yeah, remember it's aspirational. So in the same way, for people that do not yet necessarily understand natural law and have that understanding, that framework itself helps bring about that knowledge of natural law and enhances people's sense of natural justice. So it works both ways because it's a reflection. The more you understand about natural law, the more you understand that there is a need to encapsulate those natural law principles practically in your community. And in reverse, if you understand that those laws that you have in your community, those constitutional laws, that will help you come to understand the natural law principles. It works both ways. Now, let's look at the English law tradition. The English law tradition is one such tradition that developed as a legitimate framework and reflection of natural law. The English constitution that was expressed on paper in 1215 is a set of working principles. It's an aspiration. The advantage is that there is a familiarity with it. It's already there, hiding under the surface. Yes, we have distortions and layers of obfuscation placed on top, but with our existing, authentic, genuine constitutional framework, you already have a set of principles that lie in truth. You're pushing against an open door because people recognize it. So why would you deny it? Just because it's written down, that's got nothing to do with it, right? But the English Constitution are not ideas that were invented by man. They are truths. Just writing them down and expressing them for clarity is not a problem. And it doesn't devalue it in any way just because it's written out in the Articles of Common Law of 1215. Yeah, there's an important distinction between truth and what is written. That's a key point. A constitution that is based in truth can still be written down. Now, let's just look at a different tradition. So I was talking about this one quite recently the other day in a course that I was delivering, the Himba baby song from the Himba Tribe in Southwest Africa, which is in Namibia specifically. Yeah, the Himba baby song, which is the idea that everyone in the village is taught the song of an individual. So each individual in the village, right from before they're even born, the mother hears a song and learns it and teaches it to everybody else in the village. Before that, her partner as well, who she's going to have the baby with, is taught that song. And at various important moments in that child's life, that song is sung to them. Okay, and then one of the most important points when that song is sung is if the individual as an adult it is suspected that they've done something harm, a crime of some sort against somebody. Well, what happens? They bring them to the middle of the village and the villagers sing them their song again. Why? To tell them and demonstrate to them that they're not letting them go, that they're holding them. Okay, there's a healing in that. Now that is a different kind of justice system, and it's wonderful. I was very moved when I read it, and perhaps what I'll do is I'll put the link in the description of this video of the explanation that I found on the web about this. Yeah, but the key point is that does it adhere to that same set of 10 principles that I was talking about that needs to be formed as a constitution? Yeah, it does. Yeah, it's about discretion. It's about consciousness. It's about conscience. It's about not letting the perpetrator go and just discarding them out of society. It's holding them there and being responsible. Yeah, it adheres to all of those principles. And the wise elder of the village will be similar to our king in that respect. Probably better than our recent kings, but you know, there we go. So this is about aspirations and ideals. Both the traditions of the English law and the Himba baby song are aspirational. They are ideals and intentions for how we wish to live. It doesn't mean that you won't find evidence in history where the people fall short of those ideals or were tricked out of their understanding of it. Of course. Doesn't mean that, right? It's an ideal, a template. So the clue in all of this is in the fact that the other side, want to get rid of constitutions. Why didn't they just wipe out the concept of juries much earlier? Why didn't they destroy the constitutional principles more quickly and boldly? Because they had to do it slowly and incrementally. They had to erase truth in a way that people didn't notice. That's why. So I'm going to just read these last bits. When the understanding of natural law is combined with the attempt to live in alignment with it in the context of community, a framework will arise of necessity. If you then distort that framework or fail to remember it and understand it, you will fall out of alignment with natural law. You have to have it there. It's part of natural law. We have a framework of governance in the form of our English Constitution, but we are invited not to look at it and not properly understand it, even by our own freedom movement. By teaching this information, we are like the old guard, the rememberers, passing on the insight of how we govern ourselves. Thanks for watching.